am Natasha Williams. I am a U.S. qualified attorney working in France now for about 14 years. I have quite a bit of experience with a French pharmaceutical company in dealing with transfers of data, including, of course, personal data from the European Union to the United States. So I'm going to talk to you today about the impact of the European Union General Data Protection Regulation and other reforms that have impacted cross-border litigation. I'm going to speak very briefly on 3 areas in particular, and hopefully I won't get the time signed, so I will speak very quickly. I'm going to hone in on 3 areas with respect to this new regulation in the European Union. One is with respect to data service providers. The second is concerning consent from data subjects. And the third is transfers of personal data to countries outside of the European Economic Area. So looking at data service providers, I'm first going to make a distinction between 2 actors in this process of what we call processing personal data. One is data controllers. So the current European Data Privacy Directive regulates what we call data controllers. Those are people that determine the purposes and the means of processing personal data. Now, this is in distinction to what we call the data processors, which are not regulated under the current directive. Those are people who are hired by data controllers to process personal data on their behalf, either as an agent or a service provider. So this is important because beginning in May of 2018, e-discovery or disclosure, what we call disclosure in other jurisdictions, service providers acting as processors, will be directly regulated by the General Data Protection Regulation in Europe. In addition to a written data processing agreement with the client controller, data service providers will be required to comply with a number of specific obligations that are similar to controllers, including maintain adequate documentation, implement appropriate security standards, carry out data protection impact assessments, and appoint a data protection officer. If service providers do not comply with the General Data Protection Regulation requirements, they will be subject to sanctions, as Shahab mentioned earlier, and may face private claims by data subjects for compensation. So data service providers are incurring much more responsibility obligations under the General Data Protection Regulation and are subject to sanctions also if they fail to comply with the General Data Protection Regulation. The second area is with respect to consent, and this is consent of data subjects. For the preservation, analysis, or transfer of personal data for litigation purposes, a company must justify processing based on consent from the data subject. However, the General Data Protection Regulation has raised the threshold for consent, and this is so especially with respect to sensitive personal data, in which case explicit consent is required. Passive consent, which you all may probably have had this experience in your use of websites. Passive consent, such as failing to untick a box, or implicit consent through silence, will no longer be acceptable. Consent must be manifested by an affirmative statement or clear affirmative action, such as ticking a box. However, caution should be taken when dealing with consent from employee data subjects. Consent that is given by employees through their contracts may not be sufficient for purposes of litigation. In addition, it's questionable as to whether employee consent can be freely given. So companies may need to rely on another ground for justifying the processing or disclosure of employee personal data for litigation purposes. Now, the third area deals with transfers to countries outside of the European Economic Area. As a general rule, transfers to countries for which the European Commission has not determined has adequate laws or safeguards to ensure the protection of EU personal data is prohibited. There are exceptions. This is allowed if the transfers can be justified under following certain safeguards. And with respect to litigation, you generally must satisfy one of the following three safeguards. One is data transfer framework agreements. The recipient must be subscribed to one of these data transfer framework agreements with the European Union. The first example of this, which has been all over the press, especially last year, is the Privacy Shield Framework Agreement between the European Union and the United States. This was adopted in July of last year and replaces the previously invalidated Safe Harbor Framework. Before the validation of the Privacy Shield, you can imagine during this interim period when Safe Harbor was determined to be invalid, the companies were in limbo as to which data transfer mechanism could be relied on. The Privacy Shield, however, is not without challenges. The Article 29 Working Party has already indicated in its statement to the European Commission's determination of what we call adequacy for the Privacy Shield, that they will be retaining their scrutiny at the moment of the Privacy Shield. They're putting a one-year moratorium to see how this works, but they have also underscored the fact that they will be supporting data subjects who feel that there's not sufficient protection of their personal data under the Privacy Shield. So this is an option that, a new option replacing the Safe Harbor, but it's not necessarily one that keeps companies safe from litigation. The third safeguard is where the recipient is subject to binding corporate rules, or what we call BCRs, for transfers among entities of the same group organization. The good news is that this already existed under the current directive, and the new General Data Protection Regulation formally recognizes BCRs for use by both data controllers and data processors in all member states. Beforehand, only approximately two-thirds of the member states in the European Union recognized them, but now this is something that can be used across in all member states of the European Union. Now, I've talked about three safeguards as an exception for transferring personal data to countries, or what we might call inadequate countries outside of the European Economic Area. Another alternative is transfers of personal data based on the grounds of the defense of legal claims. And when looking at this, you may feel that for litigation, well, that would be the basis upon which you would then be able to justify or legitimize the transfer. However, there are quite a bit of restrictions. This is acceptable only if transfer is occasional, involves a single transfer of all relevant information, and does not involve the transfer of a significant amount of data. So you can imagine if you're working for a multinational company that is subject to litigation, especially for jurisdictions in the United States, for instance, or the UK, this would probably not be the grounds upon which you would justify that transfer, considering the amount and frequency of transfers to these countries. For multinational, in addition, there's also under Article 48 of the General Data Protection Regulation, prohibits the disclosure of documents containing personal data in response to a request by a court or administrative authority of a non-European Economic Area country, unless there is an international agreement, such as the Hague Convention or other mutual legal assistance agreement between that country and the European Union. So essentially what is happening is that when you're looking at cross-border litigation, especially to countries that are not determined to have adequate protections for personal data coming from the EU, you will have to go through this process of mutual legal assistance agreements or the Hague Conventions to have this transfer approved. So finally, in practice, these requirements of controllers and processors pose a delicate balance between compliance with the General Data Protection Regulation and respect of the discovery or disclosure obligations in cross-border litigation. It's clear that multinational companies will need to ensure that their organization is equipped with the right people, technology, policies, and processes to ensure compliance among all those involved in the cross-border litigation process. Thank you very much.